May I start the session, sir?
Yes, madam.
Thank you, sir. A very good afternoon to everyone. On behalf of the Department of Applied Sciences and Humanities, PR Pote College of Engineering and Management, Amravati, I, Professor Sheetal Nerkar, welcome you all for today's session of IST approved 1 week online STTP on research publication, copyrights and patents in science and technology. For the session, I welcome Honorable Shri Praveen Kumar Pote, President of PR Pote Patil Education and Welfare Trust, Group of Educational Institutions, Amravati. Honorable Shri Shesh Pote, Vice President, PR Pote Patil Education and Welfare Trust, Group of Educational Institutions, Amravati. Honorable Dr. D.T. Ingole, Principal, PR Pote Patil College of Engineering and Management, Amravati. Honorable Dr. Muhammad Zoe, Vice Principal, PR Pote Patil, College of Engineering and Management, Amravati. I welcome today's keynote speaker, Dr. Hariprasad Paikrao, also respected deans, HOD, participating faculties and students. For today's STTP session, we are having well-known name from Faculty of Science, Dr. Hariprasad Paikrao. He is MSc PhD. He has done his research in biotechnology and qualified NET in agriculture biotechnology. Currently working as assistant professor in Department of Forensic Biology, Government Institute, Amravati. Sir has published more than 18 research papers of national and international repute and proudly 5 patents to his credit. Also, as a research guide, Sir actively completed 2 research projects at Sant Gadkar Baba Amravati University. Let's welcome such an eminent personality to deliver his lecture on technology transfer, patents and copyright, and overview of intellectual property. Please, sir.
Thank you, ma'am. Am I audible?
Yes, sir.
First of all, I thank all the respected dignitaries present in the session, and I'm starting with my presentation. First, I'm sharing my screen, but ma'am need to enable me for sharing the screen. Hello, ma'am.
Wait a minute, sir.
Yeah.
Sir, once time try.
Yes, ma'am. Yes, ma'am. It is okay now.
Okay, sir.
Yes, ma'am.
Okay.
Is it visible now, ma'am?
Yes, sir.
Okay. Okay. So a very warm good afternoon to all the respected dignitaries in the session. Today, my topic of this seminar is regarding intellectual property rights. So now we all know in today's era, there are different types of properties which a person holds. It may be a movable or a immovable property, which he or she gained through the either his or her hard work. But there is one more property that we can see is regarding intellectual property. So the movable property can include car, pen, furniture, or various other examples are there. Immovable properties can be like land, buildings, and other things. But the intellectual property, the property which a person is gaining through his intellect or by virtue of his strengths, is nothing but the intellectual property. It can include literary works and inventions. Now we'll see one by one what are these literary works that can be come under intellectual property, or the inventions which are under the intellectual property. Now, when we see what is the nature of these intellectual properties, it is a creation of human mind, that is nothing but the intellect. It can be considered as an intangible property. You are not able to calculate its tangition. These are the exclusive rights given to the statues. These are attended with certain limitations and some exceptions also. Means not all of these things which we used to see are patentable or which can come under the IPR. These intellectual properties are time bound. They are not for the eternity. They are something which have limitations in terms of their time. Also, these intellectual property rights can come under certain specific territory. It may be a country or a particular geographical area. So these are some objective features of an intellectual property right. When you talk about its simple definition, what intellectual property can be, it should include the rights which are relating to literary, artistic, and scientific works. These can be performances of performing artists. Like, for example, someone who is very good at his writing, or he's writing a song, or he's writing a poem, that can also come under this intellectual property. Sometimes phonograms, or many a times a song which is being sung by a singer, but the broadcaster is different. So that broadcasting can also become under the intellectual property. Then there are certain inventions in all of the fields of human endeavor. Whatever the inventions that are going to take place by the human intellect are or can be patented under this IPR. Similarly, scientific discoveries which are having specific role in human development. Industrial designs, many times we used to see that specific designs which are applicable in industry and having a wide use can be considered under the IPR. Similarly, trademarks, service marks, commercial names or designations, commercial designation in terms of the trademarks we are talking about can be considered under this IPR. So when a person holding an IPR having a right of protection against unfair competition also. So these are some things which are being protected under this intellectual property rights. When you talk about the historical background of IPR, we see that there are different conventions took place to proceed for the current IPR guidelines. It may be a Paris Convention for industrial property rights that was in 1883, or then Berne Convention in 1886, and many more like in 1991, 92, and then there is an agreement which is of trade related aspects on intellectual property rights in 1994, or some internet treaties also. So all of these things took place, or they made current guidelines useful for IPR. What is the basic principle behind this IPR? It is nothing but a protection for revelation of the discovery or revelation of the invention. Means unless a person is having the guarantee that his invention or his discovery is been protected, he is not going to reveal it. So that is why the IPR is been under the lens to provide a contract between the creator, the person who creates the invention or who discovers the invention, and to the sovereign state where he resides. That is the contract can be considered as IPR. It is also a balance between rights of creator and public interests. There is nothing but a limitation to these rights. IPR is not only to provide all of the benefits to the creator, but there are certain limitations and exceptions also. In the coming slides, we are going to see what are these limitations and exceptions. When you talk about the types of these intellectual properties, mainly they can be classified into two: copyright and related rights and industrial properties. These are the two major types. We are going to see the copyright and related rights in the coming section. But when you talk about the industrial property rights, it can have several other subtypes. It may be patents, industrial designs, trademarks, geographical indications, layout designs in the integrated circuits, trade secrets, and then protection of new plant varieties. All these things are the subtypes under industrial property rights. When you talk about the context in India of these IPR, there are specific laws which are related with IPR, like the act which is in the 1957, provided by Ministry of Higher Education, that is the Copyright Act 1957. This act provides us the protection for all the literary and artistic works. And later on, there are different other acts like the Patents Act in 1970, very important one, which gives us the protection to all the patents. It is produced by Industrial Policy and Promotion, published by this department, and many more such acts are there, like the Protection of Plant Varieties and Farmers' Rights Act 2001, published by Agriculture and Corporation Department. So on the basis of these laws in India, we have the IPR protection in India. Now, the first topic that we are going to see is about copyright and related rights. First of all, you know what is copyright exactly. Copyright law grants the authors or the composers, or it may be software writers, website designers, and other creators. In short, we can call them as a creator, which having the legal protection for literary and artistic creation. And it has been referred as works. Literary means whatever he is having in the form of certain poem, songs. In terms of software writers, it may be a code. So such creative expressions can be considered under the works. For example, I can show you that novels, poetry, music, paintings, photographs, sculptures, architecture, films, video games, some of the databases, all will be considered under this copyright protection. And the rights enables the owner. Now, owner here is nothing but the creator. As soon as a person creates something in terms of literary or artistic work, he will be now considered as owner of that work. And within a specified period of time, he will enjoy the protection of those rights. Now, it can be to control the use of his work in a number of ways. It may be of reproduction, or it may be of modification, or the owner can also receive a remuneration for the work that he produced. What are the requirements for this copyright protection? When a person can get the copyright protection, the person can only get the copyright protection when the work that he produced is original. Unless it is the original work, he is not going to have any of the, let me show you by, just a minute. So if it has to be original, unless it is original, you are not entitled for this copyright. Now, what is this originality means? This originality should related with the expression of thought. It should be related with the expression of thought and not to the underlying idea. Underlying idea के लिए नहीं मिलेगा, but expression of thought. Okay. So someone who is having an idea that he is going to create a song, but that idea is in his own mind only, and that song is not on the paper. So that idea cannot be protected under this copyright unless and until he is going to write a song on a paper. Means that expression of thought is there in a hard format. It cannot be protected under this copyright. The originality should also be reflected in the fact that the work is independently created. It has to be created independently and it should not be copied from somewhere else. So it is a very important requirement for a copyright. The work enjoys copyright protection irrespective of their creative elements, quality or value. Means the person who is enjoying that copyright protection, not necessarily he should be genius in that field. He can have a literary or artistic work. It can be meritorious work or it can be any general simple work. But if it is original and if it is in the form of expression of thought, it is not copied from somewhere else, then it is eligible for protection under the copyright. So when you talk about the other materials, like what are the different materials can be copyrighted? Books and other written materials. It includes books, it includes journals, it includes source codes also. Like here you can see there are some software codes can also be come under this copyright protection. Music elements, it may be like the CDs which has been run with the particular song, filled with the particular song or any other material. Television, movies, games, all this will be coming under the copyright. Now there are two types of rights that can be protected by the copyright. Mainly moral rights and economic rights. Moral rights are to protect the personality of author and economic rights are to bring the economic benefits to the author. When you see in the details, what are these rights? We can see that moral rights are those which can be of two types mainly. Again, these can be authorship right or can be paternity right. Means whenever a person creates a work, it may be a poem, it may be a song, it may be any other literary, it may be a book. If he creates that work, his name, his or her name should be kept as an author of that work. That right is been termed as authorship right or paternity right. Means the right of authorship cannot be taken away from that particular person. Similarly, the right of integrity, right to protect the integrity of work means what? Whenever a person is creating such literary work, and if by chance he is giving some permission to make that literary or artistic work commercial to any other person, which is nothing but it can be a broadcaster or it can be any other person. Still, the author or the owner has the rights to prohibit any changes, modifications, or alterations to the work that would damage author's honor or reputation. There is an example, famous example of the Dr. Sehgal. During 1950s, Dr. Sehgal was the one who created certain sculptures in Indian Parliament. But after some time, those sculptures were removed from Indian Parliament. But when Dr. Sehgal came to know about this, he went into the court and he won that particular case that without his permission, those sculptures cannot be removed unless and until the owner, or we can say here as the creator of that sculpture, is permitting or granting that permission. So this particular moral right that is known as protection or integrity of the work, right of integrity, prohibits any changes. Changes cannot be made into that literary or artistic work if those changes are going to damage the author's honor or reputation. Similarly, though a person is selling those copyright to any other broadcaster, though the moral rights of that person cannot be transferred to someone else. Moral rights of that particular artistic work cannot be transferred. Moral rights can be waived in certain cases, certain countries especially, whenever by means of certain written agreement for a specific period of time. Then there are some economic rights of the copyright under the copyrights. Economic rights are those which are going to protect author's economic interests and allow the author to earn a profit by direct or indirect exploitation of work. Means whenever a person creates something in terms of literary or artistic, that work, if it has been commercialized, the benefit of that work should be given to the author in terms of money. Monetary benefit should be there. What are the exclusive rights under these economic rights? Make reproduction of those work, means it can be reproduced, or copies of that work can in various forms. Like if it is a book, that book can be published by that particular author either in written matter or in the form of soft copy, or any other manner can be reproduced. Distributed the work to the public, renting or lending the copies of the work is also a economic right of that person. Make translations or adaptations of the work has to be given rights to the author mainly. Now author here is the one who have created the work. We can call it as an author. Communicate the work to the public, perform or show the work in public. So all these things are exclusively given the rights to the author. Unless he has a right to sell these to specific people. So once he is selling these economic rights, then he will not entitle again for these rights. But moral rights are different. In moral rights, though you are selling these economic rights to another person, you are having the moral rights with you. It cannot be transferred. Same things we can see here also. What are the different economic rights are there? Adaptation rights, like we just talk about whether conversion of any artistic work into another form. Literary to the drama. For example, a book is been published by an author, so that book can be converted to a drama or a movie, but the rights should be with the author mainly, unless he is selling those rights. Abridgment means a version of book that is shorter than the original. This can be a abridgment. So if a book is in its longer format, but you can also make it in a shorter one by the permission of author only, or author has the right to do that. Picturizations or comic formats, conversion of those literary works into picturization or comic things. Right to make a cinematographic film or sound recordings. Translational rights, rental rights, resale of rights for the original artistic works. All will be considered under the economic rights. Ownership of rights. Person can own the copyrights from the author. Who can be taken these rights? Like literary can be from the author. If any drama is there, it can be a dramatist can be an author. If a music is there, a composer will be an author. Similarly, photographer will be an author for a photograph. Sound producer can be an author for a sound recording. So these owners have the right for their specific things. Now there are certain exceptions, like what are the exceptions? Whom we cannot consider under this Copyright Act? Like those who in the course of employment creating something literary or something artistic cannot be considered under copyright. Employment by newspaper, magazines, photographic, painting, who pays the money for that particular, means the person who is under certain job to do these things cannot be considered under the copyright. These are the exceptions. Like lecture delivered in public, the person who is delivering is an exception for this copyright. Similarly, government work is there, that can also be under exceptions. Like work of apprentice, a teacher cannot be claimed for a specific lecture that he is going to deliver is under copyright. Paper setter, question papers, if you are going to set a paper, it is not also under copyright. So there are different exceptions. Now, what are the different processes for securing the copyright? So securing a copyright is, we can say, just mere a formality for protection. Because as soon as you written something in an artistic or literary work in the form of expression on paper or any other format, you are entitled for that copyright. It is not necessarily that you should register it under Copyright Act. Means registration does not matter of law established, that what is registered is in fact in law copyright subject to matter. Okay. Duration of copyright that can be given to any person. Literary, dramatic, musical or artistic works can have a duration of life plus 60 years. Means if an author is living, so his life plus 60 years duration is there for the copyright. All other works can include posthumous or anonymous work. If a work is there, if a book is there, but that book's author is anonymous, in such case, 60 years from the date of publication. And once this period completed, 60 years period completed, then that work, the literary or artistic work, is now open in public. It is now open in public for others to use it, to reproduce it, or by other chance, you can perform the other. Just a minute. audible now? Hello. Hello. Am I audible, ma'am?
Yes, sir, you're audible.
Okay. So these are the things where we can protect the artistic or literary work. Now, when you talk about the copyright related agreements for the different cases, like for example, in case of a song, the composer or music or songwriter lyricist related rights will protect singer and musicians who are performing the song, producers who are made the song recording, and broadcaster that produced the broadcast program in which the song was broadcast. So there are some related rights also, copyrights and some related rights. The related rights are also called as neighboring rights. Neighboring rights. What are these neighboring rights? The neighboring rights are those which are protecting other peoples which are involved in a particular work. For example, just I shown you this particular example. In case of a song, if it is been written by a lyricist, so it is not only the lyricist who is entitling that copyright, but also the composer who is composing the music, the songwriter's lyrics, similarly the singers and musicians who are performing the song, producer who made this recording, and broadcasters who that produce the broadcast of the program. So all of these will considered under the copyright. So these neighboring rights can be for performers, like I just told you. Performers can include actors, musicians, singers, dancers, or generally people who perform can be considered under this performers. There are three kinds of related rights. One is performer, another is producer. Producer is of sound recording in the recording, cassette recording, compact disc, or any other media. And then there is a broadcasting organization in the radio, television programs, and in internet broadcast, such as podcasts. All will be considered under related or neighboring rights, these people. What are the rights they have? The related rights of copyright. If you need to obtain the consent of the performer prior to recording or to live performance by cable as well as reproducing the recording, means you cannot reproduce the recordings unless you get a permission or a consent from the performer. Producer will entitled for legal right in the recordings and that have right to take action against unauthorized copying, use, or distribution. We see that many a times different people used to get pirated versions of different artistic works. It may be a movie, it may be a song. So such pirated versions can be under the unauthorized copying format, and it can be punished by specific laws. Broadcasters, they enjoy the right to control the broadcasting, rebroadcasting, recording, and reproduction of their broadcast. So these related rights are protections which are offered by independent of the copyright protection that may exist in the works being performed, recorded, and broadcasted. So we can see that these are some broad copyrights and some related rights which can come under property right. The performers having the duration of 50 years, performers' rights. When you talk about broadcasters, they have the duration of 25 years from the recording of that particular work. Now, when you see that if you want to go for filing of this particular copyright registration or copyright registration workflow, what things we can do? Copyright can be filed by visiting Copyright Office of India. Apply with your work, whatever the work that you have created. It may be a literary or artistic work. The application along with the respective fees, it may be online payment or through the DD. Then once you fill the application, it will be published in a diary. There is a title called as diary. Under that title, the work will be published. Once it is issued in a diary, 30 days are mandatory for objections. There are certain literary works which can be copied from other sources. In order to avoid that, it may be seen that some objections can be raised. So there is a time of 30 days. If a person fills application, so there is a 30-day time for any objections are there. Once the objections are filled, if there are no objections, if the copyright is the original work, if the work is original, then there is a no objection, then it will be going for the scrutiny. Scrutiny is been done by the examiner. If the examiner finds no discrepancy in the work, that discrepancy can be of any type. If he finds discrepancy, it gives a letter to the applicant. Applicant के पास एक letter जाएगा कि आपको इस तरह के कुछ changes करने हैं. So the applicant will again reply for that particular discrepancy. And once there is a reply, that will be again heard by the registrar for the particular issue of applicant. And if he see that the discrepancy is been completed by the applicant, further it gives the registration approval that for that application. Once the registration is approved, that will be sent for extracts to the register. Means your work is been registered now, completed. So this whole process is been done from filing an application of copyright to the registration into the register, copyright registration. But what if there are objections? If there are objections, then if any person is going to report objection, so the office will send letters to both the parties. दोनों parties के पास ये letter जाएगा, and both the parties will be asked for a reply, and then it will be heard by registrar. If the application is accepted, application will be again for objection for the examiner. And if it is application is not accepted, will be rejected, and the rejection letter will be. This is the whole workflow for copyright registration. We can also see that by all this workflow, you are able to get a copyright for your literature. Hello, ma'am. Am I audible?
Yes, sir. Audible.
Okay. So when you see the patents, before that, I want to show you how you can go on copyright registration site or office, and you can able to register there. So this is site where we can go directly, and once you go on the copyright office, you have to log in there. Once you log in there by creating an account, you have to go on e-filing of copyright application. E-filing of copyright application. On that e-filing of copyright application, you have to go for filling the form number 14. This is the form number 14, registration of copyright form. So once you go on copyright form, you will be asked for either your signing details and once you complete the signing details, you will be asked for filling this click here on online copyright registration. In online copyright registration, here you can see this is the form 14. We are able to see this is the form 14. You have to add your name, address, PIN code, nationality. You have to give your communication details, and then you have to accept the form. And further, in the step 2, you are able to add your particulars of your work. So this is how you can go and give your whole details for copyright of your literary or artistic works. Ma'am, is the slide is visible?
No, sir. Not visible.
Okay. Okay. Let me share. Is it visible now, sir?
Yes, sir.
So this was all about your copyright. Now the second topic that we'll see is of patents. What are patents? Patents and copyrights, they have certain differences. Patent is an exclusive right granted for an invention. You can see that it is an invention, which is a product or process that provides a new way of doing something, offers new technical solution to a problem. In this patent, you can see that it is a limited monopoly right granted by the state, enabling an inventor to prohibit another person from manufacturing, using, or the patented process without permission. The period of patents is 20 years. The difference between copyright and patent that we just talked about, the copyright, it is a kind of a literary and artistic work. It does not include any invention. While in patent, it is an invention which has a product. That invention can be of a product invention, product related invention, or it is a process related invention that we can see. What are the different things can be patented? Inventions in all fields of technology, whether the products or processes, if they meet the criteria. What criteria should be met for a process or a product to be invented as a patent or considered as a patent? It should basically qualify into these three criteria. What are these three criteria? These are novelty. First, it should be novel. Whatever the process or product or the invention related to this, it should be not novel. it should be non-obvious, the non-obviousness, the inventive step that we are following in a patent. It should not be such that it can be easily adopted by any other person who is working in the same area. So it should be such inventive that it's not obvious for any person to easily complete that. And the major third criteria, that is of utility of the patent. What is it? It means the work or the invention that is being considered under this should be industrially applicable. It should be industrially applicable. So there are three criteria for a patent to be considered under patent, that is novelty, non-obviousness, and industrial applicability. Just we talked about invention, no prior to claim by the inventor. Okay. Similarly, inventive step, it should not be obvious to a person with ordinary skill in that art. Similarly, industrial application, like invention can be made or used in any useful or practical activity, are as distinct from the purely intellectual or aesthetic one. So these criteria should be met with that of the patentability. Grant of a patent will be to those who are by specific offices under national patent offices after publication and substantial examination of that applications. In India, provisions are made for pre-grant and post-grant oppositions by others. So we'll come into when there is a filing part of the patent. What is this pre-grant and post-grant opposition? They are also, patents are valid within the territorial limits of the country. So we can see that if it is an Indian patent, so it has the validity to India and in its territory only. It will not applicable for other countries. And if you want to make that patent applicable to other countries, then there are specific patent modes which you have to adopt, like PCT publications, which having the ability now to protect that patent in all over the world or most of the countries of the world. Foreigners can also apply for the patents, like for in India we talk about. Similarly, there are other countries where Indian people can also go for patenting by using specific patent modes. These things we talked about are those which can be patented or which have the specific conditions to get patented. But what are these things or what are the inventions which cannot be patented or not patentable? Like those inventions which are frivolous or which has the claim for anything obviously contrary to the well-established natural laws. There are chances that person can claim against a natural law. For example, machine giving more than 100% of the performance. So this cannot be true. This cannot be seen in the science at least. So in such cases, we can see patent cannot be granted under or cannot be considered under these kind of conditions. Perpetual motion machine, while someone is patenting that a machine can run without any external energy for infinite time. So such an idea of perpetual motion machine cannot be considered under patents. Or those which are against the natural laws, I just told you, against the Newton's law of gravitation or other laws, then it cannot be patentable. Other things which cannot be patentable are the machines whose primary or intended use are for commercial exploitation, which could be contrary to the public order. If it is creating a chaos in public order or creating a chaos in morality or other damage to the morality or other serious prejudice to humans, animals, plant life, health and environment, such machines can also be not patentable. It may include such devices for house breaking. If someone wants to break a house and he is creating any certain machine, and again he wants to patent that, so it is not possible to patent because of these conditions. Biological warfare material devices. Sometimes it may happen that scientists in their labs accidentally or by deliberately create something which is harmful, in such cases, it cannot be patented. Similarly, we see Terminator gel technology, which is regarding many a times the seed companies used to prepare the Terminator seeds, which are nothing but the infertile seeds. So such embryonic stem cells. So these are some ethical issues or ethical things which cannot be patented under the patent laws. Similarly, if you are discovering a scientific principle or a formulation which is just an abstract or theory, it can also not be patented. Okay. Or there are certain discoveries which are just new form of the known substances. In such cases, these inventions cannot be patentable. That cannot also be patented. Okay. Substances which are just admixture, which are resulting only because of aggregation of properties. For example, we see that certain drugs like paracetamol and brufen. We know that paracetamol is an antipyretic, which inhibits the fever, and then brufen, which is analgesic, which is nothing but a painkiller. In such cases, you see that these two, if they are mixed together and asked to consider it as an invention, then it will not be considered as an invention. It will be just an admixture of two known substances of known properties. So it cannot be considered under patents. Similarly, we see that known devices and their rearrangement. Sometimes we see that two different devices, they are having their own work, and if someone is mixing them, if someone is attaching them with each other and creating a new device, considering it as a new device, but both of these two devices are already known, in such cases also it is not patentable. It is not patentable. For example, an umbrella with fan. These two things are already known, and they are working in their own way. What are other things which are non-patentable? Method of agriculture or horticulture cannot be patented. The inventions, like for example, varieties and species, means mainly plants and animals, clones and new varieties of plants. In India, we are talking about they are not patentable. Mathematical methods, business method or algorithms, computer programs. Computer program as a per se, it cannot be patented. But if a computer program can be considered under copyright, or the software which is run by a computer program and if that software is added into certain machine, and now that product can be patented, but only computer program itself cannot be patented. So that's why, like as I told, computer program claimed by itself or as a record on the carrier can be considered as patent. Non-patentable things are various other, like we just talked about copyright, like literary or dramatical, musical, artistic work can be considered as copyright protection or under the copyright protection. The topography of integrated circuits. There is a specific category under IPR which will cover this part. So it will be not considered under patents. Traditional knowledge, if we know that in our Indian Ayurvedic system, we are already aware of different types of plants and their drugs. So by just mere knowledge of these Ayurvedic traditional medicines and using it in the same way for patenting is not applicable. So such things cannot be patented. So that is non-patentable. While if you are adding certain values to those methods which are already known, like for example, traditional knowledges, and then you are creating any product out of it, or you are creating a process which is having a novel method or an inventive step to it, which is having the industrial applicability, then that product or that process can be patentable. Okay. Similarly, which are the inventions related with the atomic energy are non-patentable. Now, these are the things that we have talked about. How to file a patent application is the important thing. So when you are going for a patent application, filing a patent application, so before going to file a patent application, some of the things that we should be aware of are what are the already known processes or what are the already known patents which are there in the databases. For that, we should go for a prior art search. It is called as prior art search. Means because we know that patent which is already known or the process which is already known cannot be patented again unless it is having a novelty, unless it is having a non-obviousness and a industrial applicability, or we can say utility. In such cases, you have to go for certain prior art search. That prior art can be searched by different databases. There are different databases for searching these prior arts. So for that, I can share you how to go for searching these prior arts. Like when you talk about the databases which are there, mainly 2 to 3 databases are there, like which are able to see patent scope. Patent scope is the database which we can see. I hope you are able to see my screen now. Hello. Hello, ma'am. Can you see the screen?
Yes, sir.
Yes, can you see the patent scope now on the screen?
Yes, sir.
Yes, sir. So, as I told you, when you go for a prior art search, in prior art search, you can go and look for specific titles, like by going on patent scope and accessing the patent scope. You just have to go and access the patent scope. If you want to know what are the different already known patents related with your invention, It can be also done on InPass, which is nothing but our own Indian patent search engine. So these search engines are there where you are able to look for the patents or the related work. Google Patents is just like your Google search. So you have to go and write it down with your specific query, and you will get the results. Like for example, if I am going on the patent scope and writing some random title, or suppose for example my name only, and looking for that whether the person is having any patents or not. Or for example, I am having the artificial intelligence in Google Patents. So you can get the different types of outputs or different results of patents which are related with the artificial intelligence. We can go and search with that particular patents, and you can compare whatever the prior art is there. Now this is a prior art. ये एक paper या फिर patent which is in the form of prior art. So you have to look for those gaps which are there with your invention and the prior art, and you have to fulfill those gaps. Because if you are not going to fulfill those gaps, your patent will be not being considered as the novel. So in order to consider your paper as a novel, it should be certain things which are new to in your patents. Like for example, when you type the author name, here I can see there are different patents. Here are the patents that we can see. So by looking in the prior art search, we are able to find what are the different patents or prior arts that can be seen. Once you are done with your prior art, you have to prepare your file, and the file should be submitted to the patent office. This is the general procedure for obtaining the patent. First, filing a patent application. First of all, you have to file a patent application by going on this site, that is WWIP India Online. Once you go and do your patent application, the application can be filed by two ways. One, if you are not sure that whatever that you have created or invented is not complete. Suppose you have done certain protocol which is not a complete protocol. You want to know more of it. So you want to get more results of it. So what you can do, you can prepare a small draft of it in the form of provisional patent or provisional specification. By going through the provisional specification, you will get 12 months time to submit your complete specification. So suppose you are not having the whole work of it, you can go for provisional one, you can submit it, and then wait for 12 months. Within 12 months, you can go for the complete specification. Once the 12 months completed, for publication, there is a time duration of publication is approximately 18 months for a normal patent application. But you can also go for publication in the early time, that is called as early examination or early publication of your patent. By paying certain amount of fees, you are able to publish the patent early. Once your application or the patent is published, then there is pre-grant opposition. So the patent is published before grant, it can be given certain opposition or objections by specific representations by different persons. So that is called as pre-grant opposition. Once that public patent application is passed through this pre-grant opposition, further you can ask for examination. So your patent will be examined just like we talked about copyright, where the examiner will examine the patent, examine the work, literary or artistic work of copyright. In patent also there are certain examiners. Examiners are of different disciplines, like biology discipline, like electronics, engineering, different disciplines are there. And their examiners will examine the patent. And once examine the patent, they will produce or provide, if any objections are there, they will give you the first examination report called as FER, first examination report, where they will deal with whether the patent application is novel, non-obvious, or having the industrial utility. And if it is not, they will raise certain objections. Once those objections are raised, the application will be sent back to the person who applied for it, patent. Once that objection will be again completed, the patent will be further go for the second examination. Second examination, if it is okay, then you will get the grant of that patent. Like for example, here you can see there are different number of forms you have to fill. Form number 1 includes name, address, contact details, inventor, assignee, assignments, details of filing will include the form 3. Request of examination will be called as form 18. Form 18. Request for early publication. If you want to publish your patent within the period of 6 to 8 months, that can be done by filling the form 9. Form 9 and with paying certain fees. Then power of authority. Suppose you are not filing the patent. What you are doing, you have given the authority to your patent agent or patent attorney. In that case, you have to give this power of authority to the patent agent, that whatever the submissions will be done by the patent agent and not by me. So it is just like power of attorney given to the patent agent, called as power of authority. Then there is a document of technical information or technical specifications called as complete specification. Under form 2, you will get background of the invention, summary of the invention, claims. This is a very important part because number of also increase the number of pages. Number of pages will increase or increase will also result into increase amount of the fees. Okay, so it will depend on the claims. The claims are the thing which will very important. So this is the workflow for patents. Here you can see what are the steps to be followed. First, you have to conceptualize the invention. Once you got the concept, you have with complete specification. And if you do not have the complete specification, go for the provisional specification. Wait for 12 months. Within 12 months, you can fill the complete specification. If yes, go for the publication. Publication will be done post 18 months. For the request of examination, examiner will examine it. FER, that is examination report, will be issued. If it is been okay, then re-examination will be done of objections are met, then further grant of patent will be there. Sometimes once the patent is granted, still there will be a post-grant opposition. Post-grant opposition under 25(2), which is nothing but that there are chances after grant of patent, your objections can be raised, and that has to be opposed, or that has to be given answers to by the patent. So this is the general workflow for your patent. Now, when you talk about patent filing, you can again, I will show you how to go for e-filing. So you just go on e-filing of patents. Again, just like copyright, you have to sign in. Once you are signing, you will be asked for the patent, new patent application. And one more thing here, once you go into the, during the creation of account on patent office or a patent site, you have to be with digital signature. Digital signature is must. So digital signature should be there, or the electronic signature. So once you go on there, you have to go for the new application. Click on the new application and a new window will be opened. Now there is one condition that if whatever that you are filing, if that patent is having a material which is biologically related, if it is biologically related or if it is derived from biological things, you have to go for NBA approval. NBA is National Biodiversity Approval. So it has to be followed. But if it is not, you can go for direct filing of the e-filing of the patent application. So you go on proceed to the e-filing. Here, there are different jurisdiction for the patent offices like Mumbai, Kolkata, Chennai are the different jurisdiction of patent offices where you can go for filing of your patent application. Okay, so we talk about new application. Type of application can be of conventional application, it can be ordinary application, it can be PCT application. Now PCT application is the one which will give you protection of your invention in various different countries, not only in India but different countries. So as I told you, Kolkata, Chennai, Delhi and Mumbai are the offices. We as in Maharashtra, we are under Mumbai. So here you can see what are the number of pages in specification, number of claims, number of abstract pages, drawings, if any, number of drawings, it should be added. What is the priority date? It can also be added. The title of invention, the address for service, all these things should be added here, like abstract, description, claims should be given here. Then you have to give the applicant names, like applicant name, because my account is there, my name is already included. Okay, but if you want to add more applicants, it can be added by here, add applicants, or it can also given in the form of add inventors. Sometimes it may happen that inventor and applicants are different things. Okay, so if you want to add inventors or if you want to add applicant, by these two options you can add. And once you fill these forms, save and go for further steps, pay the fee through digital modes, and you are able to see the progress of your e-filing through this status of applications. Okay, so by visiting your patent applications in InPass, you are able to know the status of your application. Okay, so this is regarding the patent. The second IPR, which is important. Now, along with these patents and copyrights, there are other IPRs like industrial designs. Industrial designs includes the design mainly is the shape, configuration, pattern, ornament, or composition of lines, colors, which are applied to any article, can be considered under this design. Okay, it may be two-dimensional or three-dimensional or in both forms. Okay, so that is how it can be considered as industrial design. Here you can see the toothbrush here, the paintbrush, whites, pen, these are having specific designs, so that can be protected under the industrial design IPR. Different pharmaceutical products can also be considered under the shape, topography of these products can be considered under industrial design. Textile and jewelry are also under this part. What are the rights for the proprietor? The proprietor of this industrial design has exclusive right to apply the design to any article in that particular class which the design is registered. First of all, you have to register the design, and once you register that, you are having the right for exclusive right to apply the design to any article for your industrial application. The period of this industrial design is of 10 years protection period, which can be enhanced or extendable for 5 years more. What is excluded under this industrial design? The industrial design will exclude construction or anything which is in substance or mere mechanical device. Mechanical device sirf agar hai, so it will be not considered under industrial device. The device which can easily be reproduced will be not considered under industrial device. Similarly, trademark. If a device is already been considered under trademark, that can also be not considered. Property mark or artistic works, all these will be not considered in the industrial designs. What is not registrable? If it is not new or original, we know that if it is not following the novelty, as like in patents, it will be not considered as under the design also. If a design which has been disclosed to the public anywhere in the world, for example, the bottle of Fanta, the Fanta bottle design, if it is been used in India and by same design, if you want to take the protection for in any other countries, then it is not by other name or by other firm. It is not possible for them to consider under the design because it is already known. Design which is not significantly distinguishable from known designs or combination of known designs, similar to the literary or artistic work or the patents, which is two different things combined together, cannot be considered as a design. If it is under the scandalous or obscene matter, again, it is exempted. If the design is contrary to the public order or to the morality, also not considered. Various other non-registrable articles are there, like labels, religious symbols, building or construction or mere change in size, change in workshop alteration. Any principle which is mode of construction of article will be not considered as, not registered as the design. Next, we talk about trademarks. Again, it is a IPR. Trademark is a name of an enterprise or a mark, which is having the ability as a representation in the form of graphic or goods to the goods or services of one person from those of others. Means it is distinguishable. For example, as soon as I see the apple sign, as soon as I see the apple sign, half eaten apple, that is nothing but the trademark for Apple company. So it is distinguishable from all other products. So such symbol, it may be of in a graphical format, it may be a word, it may be a sign, it may be number, it may be picture, emblem, color, shape of goods, anything will be considered as trademark. It will be considered as trademark. For example, Godrej, Lux, these letters or these design will be only specific to that particular product. That's considered as trademark. like shape of goods. So any combination of the above will be considered as trademark. How to register for trademark? Again, trademarks can be registered through the website of IPS. You can go for registration of trademark. Once there is examination and publication, the registration will be made for trademark. The period of registration is of 10 years for trademark, but it can be renewed indefinitely. It can be renewed. Kinds of trademarks, like we talked about the Apple. So these are the marks on goods, service marks or certification marks, collective marks, certification marks like egg mark. Then there are different other like wool mark. So these are certificate trademarks. Egg mark, wool mark are the certification. It means it is certified by the proprietor. Service mark means it includes specific service sector, like for example, banking, education service sector, finance. So once you are having that trademark in front of you, you can distinguish whether it is of banking service, whether it is of education service, advertising service. That can be easily understandable. Collective marks, it is the trademark type where it could be associated of group of people or group of members of association, called as collective marks. Like Institute of Chartered Accountants, Test Cricketers Association, they have their own mark called as collective mark. Some of the well-known marks can be like this Coca-Cola symbol or Coca-Cola design. So you see this type of design and you know that the product is distinguished product. Similarly, Godrej symbol. Similarly, this is GE Electronics, General Electronics. That is the sign of on bulb or certain products. Different types of forms are there. What are the forms? It may be visual, audio, or olfactory. What is protected under this trademark? The protection given under trademark is to the goods or services registered as protected in the different parts of the world or different parts of the country, state emblems, official hallmarks, and any other organization cannot use the same trademark. So this is the trademark protection given to the under the trademark protection. So once we are complete with this trademark, we will now see another IPR, that is geographical indication or GI. Geographical indication is again IPR which identifies the goods as agricultural goods which are of particular geographical location or geographical area. For example, it may be, for example, basmati rice. Basmati rice is a symbol or it is a geographical tag or geographical indication, GI tag given to a rice of specific area. Or for example, Alfonso GI. Alfonso is for mangoes. So that particular mark is given to specific products. It may be from agricultural goods. It may be natural or manufactured goods originated in the specific territory of country or region or locality in that territory, given the quality, reputation, and other characteristics of such good for the geographical origin, called as GI tag or geographical indication. Like Alfonso or Basmati or Shri Ram, these are some of the GI tags given to specific products, and they are not able to seen in other geographical areas. If someone claiming that Alfonso mangoes can be produced apart from coconut from that particular GI geographical location to other area of the country, and if he is selling it as a Alfonso mangoes. So that will be protected under this GI because Alfonso can only be under the specific territory of the country. How to register it? For registration, again, you have to go for GI indication office, that is registration office, where you have to register it. Once it is published, it is valid for 10 years, but it can also again renewed indefinitely. What are the rights given to that? That exclusive right to use that particular GI tag, like Kolhapuri chappal. Kolhapuri chappal is again a GI tag given to that particular product produced from the specific territory. So it cannot be used by any other territory of the other countries or other areas by the same name. Okay. Right to obtain, and if anyone claiming by the same name as Kolhapuri chappal from other country, then in that case, he will attract the infringement of the geographical indication. Under the geographical indication, he will attract the legal penalty for that particular matter. One more IPR is of semiconductor integrated circuits layout design. So this is again one more type of IPR that can be given right for protection. This is how you can see the circuits, integrated circuits. So the layout of these circuits can also be protected. That layout design can also be protected. So you have to just go on this semiconductor integrated circuit layout design registry and register your layout in this particular part. Original and novel layout designs can be protected. Again, its validity is for 10 years. If they are not original, it cannot be registrable. Then there are trade secrets. Trade secrets, we know that some of the inventions, data, information cannot be protected by any of the available means of IPRs. Now we have talked about different IPRs. Can anyone tell me which of these IPR gives you the unconditional limit for protection, unconditional limit of protection for any of under any of these IPR that we talked about? Anyone can tell me which of the type of IPR gives us the unconditional time limit for protection? Anyone? If you can, if you got my question, you are able to answer that whatever the IPR that we have seen, is any of the IPR gives us the unconditional limit of protection? The answer is no. We have to renew it more multiple times, and sometimes it is giving a specific time period. Okay, but what happens if we want to keep it for secret or keep it to be protected under this IPR? That is nothing but the trade secret. So the trade secret is the one, the type of IPR where we can keep the confidentiality as for long time. It can be an invention, idea, survey method, manufacturing process, chemical formula, mostly formula, recipe, financial strategy, client database can be under the trade secrets. When invention is non-patentable, we can go for this. Patent protection is limited to 20 years. Once the 20 years are completed, the patent will come under the public domain, and anyone can have the right for reproduction of that patent. When cost of the patent protections are prohibited because of, or when the reverse engineering is not possible, in that case, all of these conditions can give us the idea to go for the trade secret. How to go for the trade secret or how to guard the trade secret? Trade secret is like Coca-Cola. For example, Coca-Cola. The formula for Coca-Cola is not known to anyone apart from the the 4 to 5 people which are the pioneers or which are having the stakes in the major stakes in that company. Those are only the one who are knowing that formula. So similarly, the KFC chicken recipe is also a trade secret. So, or the sausages that we used to have on our pizzas. So like Domino's or any other sauce. So those formulas or those recipes are trade secrets that are not open to all other public, any other public, only restricted to the specific people. So those trade secrets has to be guarded. How that can be guarded? By restricting the number of people having access to the secret information. If you are only restricting that particular recipe to 2 to 3 people, then again it will be a very good strategy for trade secret. Signing confidentiality agreements. If you are doing the paperwork or agreement, then it is helpful for guarding the trade secret. If you are using the protective techniques like digital data security or restricted entries into the area where the trade secret is kept or worked or held, then again it will be very good guard. National legislations provide the protection in the form of injunctions or damages if secret information is illegally acquired. We used to hear that there are certain secrets of different governments, so that those secrets can also be kept confidential by creating specific legislations, national legislations. So this was about trade secret. The last part of your IPR is plant varieties and farmers' rights. Plant varieties will include those new varieties with novelty, distinctiveness, uniformity, and stability. So all these will be examined. Once it has been fulfilled, then it will be considered under the plant varieties. Plant variety can be under the IPR. Who can get the, who can register for this? Breeders, farmers, research, where universities where research is going on, or the agricultural institutes. They can go and register for their specific variety, plant variety. What is the duration of protection? 15 years for the annual crops and 18 years for trees and vines can be given to the plant varieties. What are the rights given under this plant varieties protection? One is for production. Production can be done by a specific of that variety by the breeder. Selling, marketing, distribution, export, import can be done by that breeder. And if he is having the protection of that variety, the breeder, no other person will entertain under these rights. He will be having no rights for production or export, import, unless breeder's variety is derived from farmer variety. The breeder cannot give any authorization without the consent of farmers or the communities from whose varieties the protected variety is derived. So farmers are also very important. Their consent is also important. Only breeder cannot be given all the rights if the variety is been derived from the farmer's variety, unless it is derived from the farmer's variety. Now, what are the farmer's right? If in such case, what are the farmer's right? If the farmer who is working on that variety and his variety is been protected by the breeder, still he has the right to save, use, sow that particular variety in the field, resowing, exchange, sharing, all these things will be protected under the farmer's rights. The full disclosure of the performance of the seeds or planting material by the plant breeder has to be done to the farmer's right. Similarly, some researchers working on that particular variety also have certain rights. What are those rights? They have the right for free and complete access to those protected materials. If a variety is produced Now that produce has their access for the researchers. Now we talked about different types of IPR. Now there are different agencies which are working in this area. What are those agencies? Those agencies include World Intellectual Property Organization, WIPO, very important organization in terms of intellectual property. It is a organization which gives all the guidelines, all the resources, all the different supports for enhancing the knowledge, enhancing the knowledge in terms of the distributing the different resources in public. So WIPO is very important World Trade Organization in terms of industrial applicability. These are two important organizations. So we talked about the IPR as an overview. We have seen that copyright is the one type. The another type, which is of industrial IPR. Industrial IPR include patents. It includes industrial IPR includes patents, trademark, trade secret. Then the integrated circuit layouts. Then patent plant varieties. All these things that we talked about will be under the IPR. So it is a general overview that we have seen of IPR. Now the another topic which was allotted to me for presentation was technology transfer, IPR licensing and technology transfer. We know that once the IPR is generated under the, in any university or any research institute or any academic institute, unless it is transmitted to the market, there is no value for that particular IPR. It is only for the academic purpose now. But if it has to be given to the commercial use, then it can be done, or it can be performed by this technology transfer, or IPR licensing or technology transfer. How it is done, that we will see. Licensing of intellectual property. So the licensing is nothing but the permission granted by an IP owner. जिसके पास पेटेंट है या फिर जिसके पास कॉपीराइट है या फिर जिसके पास भी IPR है, उसको हम कहेंगे IP owner. To the another person, he will give permission to another person to use that IP on agreed terms. So there will be an agreement, terms and condition, where he will continue to retain the ownership of the IP. So the ownership will be towards the creator, but the other rights will be given to the next person. So what is the use then? What is the benefit to the creator? He will get the monetary benefit. He will get the monetary benefit in terms of lump sum amount or in terms of other like royalties. So licensing is very important. And for that, technology transfer is important. So this process is nothing but the technology transfer. Licensing conditions of IPRs. So what are the different conditions where we can go for licensing? The owner can go for licensing of agreement, or all the rights are limited, can be given, means either complete rights or some of the limited rights are given to the next person. It can be exclusive or non-exclusive. What is this exclusive and non-exclusive? We will see. Most such agreements provides the royalty for payment. Royalties can be upfront, lump sum, or part upfront, half of the amount first and half of the amount after the technology transfer, part % per production, if any process is given in the form of technology transfer, then if that process is followed by the industry and producing certain products, so per production, some of the percentage will be given to the firm which owns the IPR. The particular users for which the IP can be used are also generally specified. Is the licensing profitable? If it is, you are going to perform the technology transfer, whether it is profitable or not. So by looking at these examples, we see that IBM, the company, by patent licensing only, it about $1.7 billion. It earns $1.7 billion. Similarly, different other examples are there, which are gaining the royalties in terms of monetary benefits by just licensing the IPR. So we should consider seriously about this kind of technology transfer. Now, what is exactly the technology transfer? It is a collaborative process that allows scientific findings, knowledge, intellectual properties to flow from creators, such as the creators can be of universities, a research institute, to public and private users. From these creators, like university, to private user, it can be transferred. There is a flow. So such is known as technology transfer. Major goal of this technology transfer is to transform inventions and scientific outcomes into new products and services, which will benefit the society. Now, this technology transfer is also related with the similar to the knowledge transfer. Now, when you talk about different types of agreements under technology transfer, there are licensing agreements. What are these? These are legally binding contracts where owner of the IP, that is intellectual property, in the valuable technology, the licensors, gives someone else. The licensor is the one who is owning the IP. जिसके पास वो IP है, we will call it as a licensor. And if he is giving that IP to other person, we will call it as a licensee. The permission to use the IP in a ways that are spelled out in the agreement. जैसे agreement में आप लिखोगे उस हिसाब से अगर उसको use करना है तो उसको हम कहेंगे licensee, and that is under the licensing agreements. For example, licensing agreement is like a cake, a big cake with multiple layers on it. So what we can do, we can use specific portion of the cake, cut it and give to any other person. Similarly, if rest of the cake we want to give to other firm, we can also do that. And if you want to make more pieces of that cake and give to different firms, that we can also do. So it is a win-win situation for the licensor. Once he will get the IP. Another is assignments of intellectual property rights. One is licensing of IP. Another is assignment of IP. What is the difference? The assignment of IP is transfer of ownership. Earlier we talked about that the licensing of IP is not of whole of the rights, while transfer of ownership is there in assignment of the IP. So from the owner, that is assigner, to the assignee, complete physical or legal entity with permanent effect. If you are going to give the permanent patent or the IP to that assignee, then it will be called as assignment of IP. As we talked about the difference between these, that is licensing and assignment, that as licensing relations to the right to use of IP is temporary, while on the other hand, assignment of IP is permanent. Different types of licensing agreements can be seen, like exclusive, co-exclusive, partially exclusive, non-exclusive, and non-exclusive with option. Exclusive means when a licensor, suppose a person getting patent and he wants to grant that rights, all of the rights to the licensee, then licensor cannot grant rights to the another in terms of exclusive patent. In exclusive patent transfer or technology transfer or agreement, a licensor once gave all of the rights of patent to a licensee, he is not able to give any of the rights to any other person, called as exclusive agreement. Exclusive. Co-exclusive. In co-exclusive, the licensor can grant all of the rights to specific fields of use to a limited number of licensees, 2 or more. For example, if you have prepared a drug in terms of pharmaceutical companies. If you in a university you prepared a drug, but that drug has different applications. It is antipyretic, it is analgesic, it is anti-cancer also. So what we can do, we can give some of the drug to specific use for one company and some to the other company, called as co-exclusive. Partially exclusive, licensor can grant rights to another in a different fields of use. Similar kind of invention or the agreement. Non-exclusive, if a licensor is giving the permission or the rights to multiple parties, called as non-exclusive. Non-exclusive with option, if licensor can initially grant non-exclusive rights to a licensee to conduct research. Suppose a pharmaceutical company again, if that company gives a fund to university to do the research. Once the research is completed, then for the specific period of time, if the licensee may convert non-exclusive rights to exclusive rights, and then the exclusive rights can be limited to a particular field of use. So similarly, the specific licensor has the rights whether to take all of the rights or some of the rights to kept with that of the assignee licensee only. This is how we can see the different types of agreements. Then there are some more agreements like confidentiality agreements, where some of the things are kept confidential. It is also called as non-disclosure agreements. These kind of agreements where some of the things are kept confidential and rest of the things are open for work. Collaborative research agreements. Here, 2 or more parties are collaborating to perform or to do the research, that are wishing to cooperate to develop a commercial technology. In that case, all of the parties will invest either human, physical, or financial resources, and then you will create that particular intellectual property. So such is called as collaborative research agreement under the technology transfer. So this type of technology transfer or the agreement can be used in university to industry, university collaboration, university institute collaboration, or any particular government agency university collaboration. Consultancy agreements. Here, consultancy work can be done by university professors or researchers, or institute professors, researchers, college professors or researchers who provides expertise into the services. Specific professor having specific instrumentation or other work. Give consultancy to any company or other public. For that, the consultancy agreement can be done. Sponsored research agreement. Here, a sponsorer is there. The sponsorer can be any government body or a commercial entity like any commercial company, industry, which will give the research fund to the institutions, R&D institutions or universities, and for a specific type of objective. Once that objective is completed, then the IP generated of that objective or the research work will be protected or will be given to the commercial entity or that the government body. So such type of work is called as sponsored research agreement. Material transfer agreements. Here, some of the physical assets or tangible research materials are transferred. So this type of agreements are defining the rights and obligations of the parties which are included regarding the transferred materials, research results, related intellectual property rights. Contract research agreements. We see that many a times commercial industries or commercial companies, they hire specific department or specific universities for performing a work. So they provide the monetary benefit to that university, and whatever the output is there, that output they own, the companies own that output in the form of either IP or any other invention. Academic spin-off agreements. Academic spin-off agreements are some of the companies which are generated out of university only. So a new technology developed by a university or a research institution where newly created companies are based on that particular invention. So such are called as academic spin-off or spin-out agreements. University research-based startup agreements, like we know in Amravati University also, we know there are incubation centers where they used to give the startup funds or for startup companies for research. So such agreement is under university research-based startup agreements. Joint venture, where a business entity created by two or more parties with the objective of implementing a common business purpose. Here you are able to see how the technology transfer takes place. For example, from government giving the funding to university research, whatever the invention they have done, that invention will be in the form of technology transfer group given to different companies by no exclusive rights. So it is non-exclusive, can be given to company X, Y, Z. If it is exclusive, it will be only to a specific company. So this is a very important path from government funding to a company called as exclusive technology transfer. Here, non-exclusive technology transfer. Sometimes a industry gives funding to university or a research institute or a college, and whatever the invention is generated, that will be further under the exclusive right, can be given to specific company. Exclusive right means for the same company, or under non-exclusive right can be given to company X, Y, Z, whatever the different types of agencies are there, can utilize that particular technology through the technology transfer. So this is regarding the different aspects of IPR and technology transfer. I hope I was able to convey whatever I know regarding these things with you in this session. And with this particular session, with this particular presentation, now if any queries are there, you can ask. I am stopping here. Hello.
If you are having any question, any doubt, you can ask. I think no queries, sir.
Okay, ma'am.
Thank you, sir, for your valuable information, guidance with mesmerizing intellectual support. One announcement for the participants that feedback link is uploaded in the chat box to mark your valuable remark and attendance. Moving toward the formal closure of the day, I, Dr. Swati Chaudhary, feel privileged to propose vote of thanks. First and foremost, I thank today's keynote speaker, Dr. Hari Prasad Paik Rao, for such a wonderful session. Thank you, sir. I'm extremely grateful to the President, Honorable Shri Praveen Kumar Pote, and Vice President, Honorable Shri Shreyas Kumar Pote, for providing such platform to enhance our skills and knowledge. I express my deep sense of gratitude to the Principal, respected Dr. D.T. Ngole, and Vice Principal, Dr. Muhammad Zuel, for providing continuous support and guidance. I'm thankful to HOD of First Year Department and STTP Convener, Professor H.S. Kulat, for his continuous efforts for success of the program. And of course, STTP Coordinator, Dr. Bojne and Dr. Shahare, for their untiring efforts since the planning and execution of this STTP. Lastly, I extend my sincere gratitude to